For this week's installment of Rochelle's Daily Wire Video Edition, we're going to do something a little bit different. Ordinarily, we discuss a recent, significant new case that bears publicity in the bankruptcy community. This week, what we're going to do is to raise a hypothetical based upon a decision that just came down at the end of April, written by Bankruptcy Judge Jim D. Pappas, who is now sitting on recall status in Idaho and Montana. Here's what happened in Judge Pappas's case called Henry Anderson. The debtors, a couple, were real estate agents. They had in essence earned commissions before filing their Chapter 7 petition, but those commissions were paid afterwards. They disagreed with the trustee about whether or not the commissions were estate property, and previously Judge Pappas ruled that indeed those commissions were estate property. They didn't pay the money over, however, more than $50,000. They did, nonetheless, appeal to the bankruptcy appellate panel. However, they did not get a stay pending appeal from either the bankruptcy Judge Pappas or the appellate panel. Later, of course, the appellate panel, the BAP, upheld the turnover order that had been entered by Judge Pappas, but still the debtors did not comply and did not pay over the more than $52,000. They appealed to the Court of Appeals, did not obtain a stay pending appeal, and eventually the Ninth Circuit dismissed the appeal for want of jurisdiction because their notice of appeal had not been filed on time. The trustee, I suppose in part to coerce payment, filed an adversary proceeding to revoke the debtor's discharge. Well, Judge Pappas held that they should have their discharge revoked because under Section 727, they had failed to comply with a lawful court order. Now, I personally agree with the result that Judge Pappas reached, but what about this hypothetical, a more difficult case? What if the debtors had won in the Ninth Circuit and the turnover order had been set aside? Should the debtors still have their discharge revoked? I mean, after all, they rather egregiously failed to comply with a court order and did not get any stay pending appeal. However, of course, revocation or denial of discharge is a terrible consequence. Discharge is what bankruptcy is all about. So, had they won in the Ninth Circuit, should they still lose their discharge because their lawyer's legal judgment was right in the first place? However, they did disobey a court order and there should be some consequences. Is denial of discharge too much? Or perhaps would it have been sufficient if the bankruptcy court in that hypothetical had imposed significant sanctions for failure to abide by a court order? This to me is a really difficult case, the hypothetical I mean, because court orders need to be obeyed. If we have people not obeying court orders and there aren't much in the way of consequences, then I suppose we're in a world of hurt. Also, of course, one wonders who ultimately should be responsible here. Should the debtors suffer all of the consequences on their own, or if they rely on advice of counsel, is that malpractice? Well, these are all very interesting issues. One of these days, maybe the case will come up, but in the meanwhile, we'll find you again, same time, next week with another edition of Rochelle's Daily Wire Video Edition.